That's an interesting question. There's a couple side notes. We do have marijuana that can be consumed recreationally in Colorado. That creates a lot of interesting issues for us and for the average citizen in Colorado. The most interesting, in my opinion, component is the fact that you can be asked to take a test to show the active agent of marijuana in your body, in your bloodstream. We've scheduled, in our criminal courts, we have a rebuttable presumption as to the limit, or at least a rebuttable presumption as to what the level should be. Anything over 5 nanograms per milliliter of whole blood of the active agent, THC, which is the active agent in marijuana, there's a rebuttable presumption that you're impaired, that you're under the influence of marijuana. However, we don't have a Department of Revenue action, no suspension, based upon too high of a THC level in your blood. So, for those, for those of you who may have an extremely high level of marijuana in the blood, if you submit to a blood test, there will be no suspension of your driver's license based upon that test only. So there's no administrative action. There may be a suspension action due to a conviction of DUI down the road, but there will not be a suspension based upon the test. However, if that same driver refuses to submit to a chemical test, their license will be suspended and it will be treated as a refusal. If you want to learn even more than all the great information that I've shared with you today, you can check us out on the internet at DUIDefenseMatters.com.